Have you ever clicked an I accept button online or entered a click on an I agree box on a form without reading those terms and conditions that you have agreed or accepted in detail, simply for the purpose of obtaining free apps or services or gifts and discounts? By doing so, you may also agree to give your personal data to others without knowing it. In this big data era, personal data collected can be instrumental to scientific and medical developments and generate massive business opportunities after being consolidated and analyzed. Progress in information technology and globalization have profoundly changed the ways individuals' data are collected, retained, and used. Cybersecurity issues are serious concerns as they may lead to unprecedented challenges to personal data privacy protection. All right, I have a question, or two questions from the audience. The question number one is, any plan to require organizations of a particular size to appoint a data protection officer and make that person responsible for liaising with the PCPD on data breach matters? Very good question. Let me tell you some of the facts, Fact check one, under the GDPR of EU, there is a requirement to appoint a data protection officer in organizations. Of course, it's not, you cannot afford to have no DPOs in every organization. You can only have DPOs in certain organizations of a certain size or about a certain size. And this is a requirement in the EU. Failure to appoint a DPO, a data protection officers in the EU, will attract a fine, lower tier fine of up to 2% of the annual worldwide turnover. And also in America, there is also a requirement for public, as I understand it, a public organization to appoint DPOs. As a directive, an executive directive was signed by the then President Barack Obama, I think about 4 or 5 years ago, when he asked that in public organization, a DPO must be appointed. So that is the fact check I could assist. But in Hong Kong, we don't have such a requirement yet, and I'm not sure that it will be included in the amendment bill. But I think it will be a good suggestion to make to the government, because we can see that in organizations, including the government, there is no qualified or proper DPO appointed sometimes. Not all the time, but sometimes when you need one, they were not there. Because one, as I could see it, the DPOs are not often appointed at the right level. Despite the fact that we advocate, according to the principle of accountability, privacy data protection, personal data privacy protection should not be a matter for the storeroom or the open plan. It should be an issue to be discussed, deliberated, and decided upon in the board of directors room, not home, although we are working from home. And so it should be an issue, it should be a top-down issue, a top-down approach. If the leadership, the board of directors, if the board of directors does not talk about it, decide upon it, or act upon it, it will be futile or useless, for middle or lower ranking officers to handle, for example, a data breach. So this is, or making sure that the data security principles are complied with. So it would be a good suggestion to make to the government that a data protection officer should be appointed in each and every organization above a certain size or level, as in the case of EU.
Commissioner Wong, can I ask a follow-up question on this? As you said, currently there is no legal requirement for organizations in Hong Kong to appoint DPOs. In this webinar, I believe there are members of our Data Protection Officers Club attending, and they are playing a very important role in their organizations. Day in, day out, they make very important decisions. So what would be your advice to them to gear up themselves or to prepare themselves for heavier and more imperative responsibilities in their organizations?
Thanks, Eric. The easy answer would be just come to attend my talks and go to the webpage and then try to find out more about data protection. That's not the real or the effective way. It helps. I think the more effective way is to get involved in the work that you as a data protection officer or a data protection officers club member would do, and that is, this is your profession, it's your career. I always advise my colleagues that take your job as a career, not a single job. Okay, and then you will enjoy it. How I enjoy my work over the last 5 years, I read news, headlines, papers, articles, online or offline, about data protection every day. Okay. And I try to remember all I read every day. And then that is the way, the real way, to keep abreast of the recent development, and also be able to understand and grab the gist of data protection. And especially in my position, in a fair manner. So that is my perspective. For data protection officers club members, I would advise that they should develop some interest, okay, very keen interest, positive attitude about their job, because it is so important, not only at this time of the year, but also in future. In future, everybody will be talking about personal data security. Have a look at the recent developments, legislative developments, the mainland of China in particular. We've seen the development in Europe. We are looking at the development of data protection in the mainland of China. In the United States, they are trying to have a piece of federal legislation, okay, instead of piecemeal state legislation about data protection. So it's all over you. Okay, that's why don't give up. Okay, learn as much as you do. That is exactly what I try to do at the beginning of my public talk. I would like to share with you what I learned and what I've done over the last 5 years as Privacy Commissioner. It will take more than 3 hours for me to complete this course, okay, because I have learned so much more than I could afford to share with you. Okay, so this is perhaps my last words for the members.
That's very professional, useful, and at the same time very warm advice for all of you, I must say, Commissioner Wong. Thank you very much. So should we move on to another question?
Yes.
Here is a question which is about, hang on. Okay, here's a scenario type question. This member of the audience asks, is it okay to contact doctors whose contact details are available from government website by emailing them and sending them information about scientific information or research, but with no brands or products mentioned. So is it okay to email these government doctors?
Yeah, it all depends on the purpose of collecting the personal data of this doctor, and two, the purpose of publishing the doctor's personal detail in a public domain or public register. I believe that the information, the personal data obtained about this doctor was from a public register or public web page. If that is the case, collecting personal data from a public register within the purpose or intention of the doctor's publishing his own data, that would be all right. For example, if it is a doctor and you have some medical issues to discuss with him, or some research papers to share with him, I think that should be within the intention and the purpose of publishing the personal data for which the doctor would not mind receiving replies or feedback from members of the public. If, on the other hand, or on the contrary, the purpose was to, for example, in doxing cases, trying to intimidate, trying to smear the image of the doctor, or trying to create a wrong image of the doctor without justification. So I think this is something that we could safely say that the intended action on the part of the persons sharing information or research work with the doctor is all right.
Right, okay. Thank you very much, Commissioner Wong. Here comes another question, which is about retention of data. This member of the audience asked, for the purpose of formulating data retention policy, can you advise or can you give some guideline or best practice as regards the retention of different types of personal data?
Yeah, it is again a very good question indeed, because this is one of the issues that we are trying to make recommendations to reform our current legislation. For the time being, as I explained earlier on, there is no particular period of time or retention period of time. It is a matter, as I explained also, originally the legislation was intended to be principle-based and also technology neutral. Of course, we are beaten by the development of technology so hard that we feel it's necessary to bring in amendments and reforms. And this is one of the areas that we believe that a reform should be made. But having said that, it is very difficult to define a certain period of retention, a straitjacket, if I may, for all purposes, for all industries, for all kinds of data. So we believe that we should ask the organization to formulate a policy, a retention policy first, setting out from their point of view the satisfactory or maximum period of retention for their particular purposes. So nowadays, currently, our DPP, Data Principle Protection number 2, suggests and only suggests that no longer the data should be kept or retained no longer than necessary. I mentioned about Section 26 earlier on. It is about the erasure or deletion of personal data collected, when it is no longer required. But I think, again, what does it mean by being no longer required? We believe that if we set out in the policy, in the retention policy of each and every organization, very quite clear and open, make it transparent about it, that no, this is a period of retention that we will keep the data for, and before they collect the personal data, and this will be the best way forward, I believe.
Okay, thank you very much, Commissioner Wong. Moving on, here's a question about law reform. Commissioner Wong, in your presentation, you shared your observations about the need for updating of our privacy ordinance. This member of the audience is interested to know whether there is a timeline for the amendments to this legislation. And in particular, he or she would like to know when the amendments will be passed.
Yeah, it's a $6 million question. When it will be passed? We are lucky, to be able to present it, albeit the directions of amendments in June last year. Time flies. It's been a year since we had the recommended directions table in LegCo. It would be very difficult to estimate whether we would be able to have the issues discussed again or tabled for the purposes of introducing an amendment bill into LegCo. Worse still, it would be very difficult for us to make any educated guess about whether a bills committee will be set up, whether the detailed draft provision will be deliberated, and whether the bill will be passed within the year or so. So I just hope that this bill will come to one of the priorities, the top priorities of the government in the next LegCo session, introducing a draft amendment bill as soon as practicable. Thank you.
Okay, thank you. Thank you, Commissioner Wong. Here comes another question. Commissioner, you talked about the pressing need for a review of the legislation and the need for enhancing your office's powers to enforce the law. So this member of the audience would like to know what's the rationale behind all these proposals to give you more powers to enforce the law?
Okay. All public authorities would love to have more power, because we have these statutory duties, to enforce the law. If you are asked to enforce the law without sufficient powers, it will be a very difficult task for the enforcement department. Just imagine if the police, is not given enough power in terms of fighting crime, for example. I think it will be useless, to ask the police to fight the crime again, because they don't have the adequate powers. For us, we didn't expect this sort of enforcement power, to be fair, at the start of the first decade, or when the legislation was enacted. And that was simply because in those days, as I tried to show you, how I purchased a property, back in the 80s or in the early 90s. Okay, in fact, nobody would take it that disclosing a personal ID number on a daily newspaper would not be allowed, or would be an infringement or violation of the data protection principles in those days. So now the world has changed, but our enforcement powers has not. Now the technology has changed, but our enforcement power has not changed, or has not been able to keep pace with the change or the development. So this is something that we would like to suggest. In particular, when everybody is talking about privacy nowadays, wherever you go, if it is in your interest, in your favor, people tend to say that I don't need my privacy because I have nothing to hide. But if it is not in your favor, not in the benefit, in your interest, you will say, no, this is my privacy. I'm not going to tell you, I'm not going to share with you. So in these circumstances, it would be it would be imperative for an enforcement agency to be able to find out what the truth is, to identify the black from the white, okay, to enforce the law fairly, okay, and we need certain power to ask for documents, materials, and if necessary, to search and seize those documents and materials. And where appropriate, we'll need to apply for a search warrant first, and then we can go to ask for a statement under caution, for example. We don't need to go back to the police for a statement, for the statement to be admitted, to be admissible in court proceedings. Okay, so these sort of powers we need to make sure that the law is fairly enforced. If we have the prosecution power, for example, we'll be in a position to decide when and why we need to take the offenders to court, or for whether criminal or otherwise. But we need to be able to make decisions promptly. We need to make decision. We need to make sure that the deterrent effect, as envisaged in the ordinance, in our law, is expressed clearly and hopefully effected or promptly and effectively and so that we will be in a position to ensure that the law is enforced fairly and effectively. So this is something we need to have for the future, okay? And in the light of, or in the wake of what happened over the last 2 years in relation to, for example, data breaches, criminal doxing, and so on.
Thank you very much. I must say that's a very gentle way for our regulator to ask for more enforcement powers to enforce the law. That's very impressive. Okay, moving on, here's another question. Commissioner, you talked about the right to be forgotten, and this member of the audience would like to know more about it, as well as the idea of data portability, which sounds like a rather novel or new concept in the context of Hong Kong. This member of the audience would like to know whether you would expect increased rights for data subjects in terms of data portability and the right to be forgotten here in Hong Kong.
Yes, for data portability, I think it will. I just briefly mentioned about the benefit or advantage, of having data portability right in for example, in Singapore. Okay, they take the view that it will enhance the ease of transfer of one's data. One data subject from one data user to another. Okay, so this is the intention. I believe that is the right way to help to ease out the transfer of personal data from one enterprise to another, for example. In Hong Kong, we have thought about it, but we haven't included, I believe, this in our direction of amendments yet, probably because of the lack of urgency or pressing need, as we say. But it is, as we say, is put on the back burner. We keep it warm, and we'll use it when we need it or when it's ready, for example. So this is one area of law that we bear in mind without without including it in our current proposals yet. Okay, so that is portability. Another one, which question? Yeah.
Right to be forgotten?
Yeah, right to be forgotten, yeah. Again, we haven't included this in our current direction for amendment. Main reason is that there is some sort of protection under our current legislation by requiring under the data protection principle not to keep the personal data for a period longer than is not necessary. Under Section 26, if there is a request to remove or delete the personal data, which is not required or necessary, the request must be complied with. Okay, so we believe that to this extent, we could still offer some remedial assistance in case there is a breach, a similar breach. And we believe that this is something that would not attach or attract, a pressing need, so that we could wait for a while, and before we finalize the recommendations on the right to be forgotten. It is not quite a right, but we have some sort of measures under the current legislation to handle and deal with the situation or cases of this sort.
Okay, thank you, Commissioner. Here is another question, which is about cross-border data transfer, which is a quite topical issue in recent days. This member of the audience would like to know your comments on this issue, cross-border data transfer, and in particular, Section 33 under our ordinance, which governs the transfer of personal data from Hong Kong to other places. So would you like to offer any observations and comments about this issue, in particular the future about the regulatory framework of cross-border data transfer?
Yeah. Cross-border, or when we transfer data from or between the mainland or Hong Kong, we say it's a cross-boundary transfer of data. So when I say cross-border, I also mean cross-boundary too. Cross-border transfer is becoming more and more significant nowadays, because we always say, there is no border for data because of the development, the ICT development, and also especially the internet services and so on. In terms of enforcement, of course, we have a global enforcement network, to address the issue I mentioned about the GPA, for example. But for transfer of personal data outside Hong Kong, okay, we have a provision under our current law, that is Section 033. You rightly mentioned this Section 33, despite the fact that it has not yet come into force yet. The reason for not coming into force is that we had previous consultation about the enforcement of this provision, and the finding was that there were some views, if not opposing views, expressed by the industry of Hong Kong, and then later on we found out that also by the SMEs of Hong Kong in relation to the cost involved and the resources that they will have to allocate to complying with the requirements under the under Section 33. If it is to be enforced, the additional cost, additional resources implications would be tremendous. So when I took office 5 years ago, I also tried to understand more and try to persuade the government to have this Section 33 in force or in play or in action again. I tried to activate the enforcement of or the implementation of this provision. And then we conducted, in fact, first another round of consultation was conducted by the government. And then we follow up, to have another second round. Without giving you all these boring details. And what I could say is that now we have come to some, not achievement, but products of our previous years of work. In that we have experts advising us on the ways forward, including drafting standard clauses before, when we don't have the Section 33 in force, we might help the industry, the organizations in Hong Kong, to transfer data out of Hong Kong by adopting one of the recognized modes of personal data protection as stipulated under Section 33, and by even drafting the standard clauses for the use of the enterprises, so that they can build in these clauses into their contracts, or commercial or otherwise, so that the data transfer could be made possible out of Hong Kong to other jurisdictions. Unlike Korea or Japan, where they have adopted the other mode of data protection, cross-border transfer of data, by passing the adequacy decisions, okay, in the EU system. And we haven't even started to think of these adequacy decisions of the EU yet. But so far, I asked my colleagues whether, despite the fact that over the last 20-odd years, 25th now, okay, since the enactment of the ordinance, we haven't had one single complaint about the Section 33 not being enforced, because we have been adopting other methods. The whole concept, the whole idea is to make sure that the destination jurisdiction to which the personal data is intended to be transferred has the same protection, the same standard of protection and protective measures in place. And we could do it by, for example, static clauses, including the contract, on which we have now experts drafting all these clauses for the industries. And I believe that we'll produce a new version of our guidelines on this cross-border transfer of personal data very soon.
Thank you very much, Commissioner Wong. Your answers are most informative, helpful, professional, and forward-looking. So thank you very much. We've got a stream of inquiries, questions coming in, but I'm afraid I have to call an end to this Q&A session because we are running out of time now. But just very quickly, for the quiz that we have just done, I'd like to give you the answers. For question number 1, the PDPO was enacted in 1995, and our website is obviously tcpd.org.hk. After this webinar, we will be sending through the email addresses that you have provided us, the presentation file of this webinar, a feedback form, and an opt-in form in case you would like to receive PCPD's promotional and educational material. So thank you very much for your support and attending this webinar. Commissioner Wong, would you like to say?
Oh yeah, just one word is that as I said, I couldn't have shared with you within the last 3 years of what I learned and what I did over the last 5 years. But the upside is that I have developed a bad habit of uploading what I learned, what I wrote. I have made more than 500 talks and written more than a few hundred papers in Hong Kong and around the world, most of which can be downloaded from the website. That's why we ask you the address of our website, because this is a pool of knowledge, a pool of experience, sometimes very bitter experience, that I share with you online, and hopefully you will find it very useful. Thank you so much again.
Thank you very much, Commissioner Wong. Thank you. And thank you for all of you who have attended this webinar. So see you next time. Bye.
Bye.